I'm really happy to talk to you about the topic today because I think it's urgent that as many people, as many U.S. citizens as possible are aware of what is actually going on in our country. My big concern is the First Amendment, and is it really the law of the land, and how does that all work? So the topics that I have here: charitable choice, faith-based initiatives, the Religious Freedom Restoration Act, the Compassion Capital Fund, spiritual care, and the provider refusal regulation, which is really called the provider conscience regulation, but we like to call it the refusal. These are all issues that I think are urgent and primary. It's really important for all of us to understand. We will not have time to go through all of these today. Eventually, I guess I'll break it down into different talks. But I wanted to start to talk about the history of non-governmental organizations providing taxpayers benefits for social services. Originally, for a very, very long time, secular and religious organizations were providing these benefits for taxpayers. Some secular organizations that have been doing this in the past are SEEDCO, which is an organization that actually goes into the local communities and trains local organizations on how to apply for government funding to provide for social services within their community. I list the Resource Center for Women. It was an organization that I was on the board of in Pinellas County in my home state of Florida for a long time, that accessed government funding to provide services for, when it first started out, they were called displaced homemakers, but for women that found themselves without a job and without a partner. Maybe they died or they were divorced, to help them establish a career again. The religious organizations that were originally involved were ones that you're probably familiar with: Catholic Charities, for instance, the Salvation Army, the Jewish Federation, just to name a few. Although the Salvation Army, since what's happened with the Bush administration, has moved from being as secular as it used to be to being more religious-based. The requirements for all were that they had to establish an IRS designation of a 501c3. They had to open up a separate checking account to keep the funds that they got from the government, and that they were not allowed to discriminate in hiring or in folks that volunteered or served in the programs. The additional requirements were that there would be no proselytizing allowed, no religious icons allowed in the rooms where the services were provided, and there actually were no problems. So I have this listed as charitable choice under 3 different presidents. So charitable choice was language that was meant to be inserted into social services bill, not as a standalone act or as a standalone bill originally. So it was brought about by John Ashcroft. Actually, it was the baby of John Ashcroft when he was then the senator, and it was a compromise. And I think I actually have these out of order, but the bill, the language was originally inserted into these 4 bills or acts: Temporary Assistance for Needy Families, or TANF, in 1996, which was a Clinton signature piece of doing away with welfare as we know it. Also, the Personal Responsibility and Work Opportunities Reconciliation Act, which was the welfare to work grants that was done at exactly the same time in 1996. The Substance Abuse and Mental Health Act, or SAMHSA, in 1998, and the Community Development Block Grants in 2000. So Ashcroft essentially created a solution that caused problems where there were none. So he insisted that there was discrimination against religious organization in the dissemination of federal funds. And his aim was to remove neutral safeguards and allowed for hiring and volunteering discrimination based on affiliation and beliefs. and it allows taxpayer dollars to be mingled with religious funds. So charitable choice in a nutshell does away with the safeguards. It does away, so now if you go in and, for instance, if it's a substance abuse, if it's something like the AA program, or any program like that, religions can now use their church to hold the meetings in. They can have religious icons on the walls. They can actually proselytize the way it's headed right now, and they can discriminate in who serves, who the staff is for the program. And so if you were Jewish and you were applying for the job and with Catholic Charities, they could deny you employment based on your religion because you were not Catholic. And it's not just what your religion may or may not be, but also whether or not you abide by the religious tenets. So, for instance, if you were a lesbian, if you were a beneficiary that was a lesbian, you could be denied services because the religious organization didn't agree with that situation. So as it marched along, it got even more egregious, and there have been rulings now that have come out of the Bush administration that allows for funding of religious activities, including paying for building additions. So there was actually a regulation that came out that said if you got these taxpayers' dollars to administer these programs and you use them to build an addition to the church or the mosque, to provide the services, that when you stopped providing the services, then the building reverts back to the religious organization, and then they can use it in any way they want to. So we are now in a position of seeing taxpayers' dollars funding the building of churches and mosques and temples and so on. There is now also no protection for beneficiaries against religious bullying, including proselytizing and the displaying of the icons. And it's really detailed and hidden in the way that these things are done. I've put these into simpler, as simple a way as I can, but the way that the regulation is written for no protection for beneficiaries is that in some regulations it says that if a church or a religious organization is going to be holding this in a place or and the beneficiary objects to it, if they're savvy enough to object to it, then the organization, the religious organization, has to provide them with a secular alternative. But this is really difficult in rural communities where there may not be a secular alternative, where they could be the only game in town, and there really is nowhere else for these folks to go. And in the old days, the way that the programs were administered, they had to hire an executive director and staff members that had experience in the program, had some knowledge, had some education in the program. They no longer have to do that. The only requirement for being hired these days, if the organization chooses, is that you're of the right religious affiliation. And what they can do is not hire somebody from the outside, an executive director or staff member, and use the taxpayers' dollars to pay them. But what they can do now is use somebody that they've hired with religious funds, that they pay with religious funds, and have them administer the program. And therefore, they don't have to follow the rules and regulations because they're not being paid for with the taxpayers' dollars. The other thing is that the government is allowed to monitor and audit religious organizations if we had the political will, if we give them the money. But the fact of the matter is, under the new regulations, nobody bothers to do that. So we don't even know if these programs are, even if they're effective, if they work or if they don't work, because we're not collecting any statistics or any data on them. So in 1963 and 1964, when they established the civil rights laws, when they first did that in that big rush, they didn't exempt religious organizations from using religious dollars to hire religious employees. So they came along and corrected that in the later 60s. But what Charitable Choice does, it aims to override civil rights protections. So how did this happen? this happened because of, in the name of bipartisanship. So we have to be careful what we ask for because we might get it when it comes to bipartisanship. So back then in 1996 when this came into effect, it was signed by President Bill Clinton. And he used signing statements to limit its scope. And he didn't think beyond his presidency of what would happen when another president with another point of view came into power. So charitable choice under Bush. So we're going to go from what I've just told you about was charitable choice under Clinton and those 4 bills that it was originally written into in the late 90s. So, and this is then when the Office of Public Policy opens up in Washington, D.C., and we're on the scene, and we are working in coalition with the CARD Coalition in this case, which is the Coalition Against Religious Discrimination. And SAMHSA comes up for reauthorization. And SAMHSA is the Mental Health Act, and every 10 years laws that are funded come up for reauthorization, and they can be completely rewritten from the ground up every 10 years. They have to pass the House, the Senate, it has to be signed into law by the President again. Actually, the first thing that we worked on was Head Start. And Head Start is the program that promotes readiness by enhancing the social and cognitive development of children through the provision of education, health, nutritional, social, and other services to enroll children and families. So what happened was the Senate, for some reason, decided to take up SAMHSA. Usually, and everything's a generalization, as you all know, because you're a very educated audience from where you live and what you pay attention to. But it usually comes up in the House first. But for some reason, in the Health Committee, which at that time the chair was Senator Ted Kennedy, decided to take up the reauthorization of SAMHSA. And written into SAMHSA, as you saw from the Clinton administration, was the charitable choice language. So what they decided to do in early 2007, the committee, is to take out charitable choice and take it off the table in their discussions and negotiating what they were going to do with SAMHSA. And SAMHSA really does need to be reauthorized, because if they don't do it for the next 10 years, then they just reauthorize it year by year. In any event, they worked for 9 months in secrecy, the committee. We didn't know about the fact that they were looking at, rewriting SAMHSA. And on December 24th of 2007, we got it. Most of us had gone home for the holidays. We got an urgent phone call from our coalition leader, which in this case happens to be Americans United for Separation of Church and State. And the SAMHSA coalition, the organizations that administer SAMHSA provisions, called the CARD Coalition to say, we need help. This is going to come out. It's going to come out January 4th. And they're going to leave charitable choice in it, and we don't want it. We want it out. We haven't been able to convince them. Will you help us? So we did a conference call on December 24th, an urgent conference call. We drafted a letter on the telephone. We sent it to the leaders of the Health Committee, which is the Health, Education, Labor, and Pension Committee of the Senate, and sent it to them, asking them to stop, because their plan was they had worked for 9 months. They had come up with a bill that was bipartisan that they thought they could pass, and with charitable choice, what they did is they just stuck it back in the bill. They just never discussed it. So we wrote them a letter, and we asked them to stop and told them that, we would take action if they went forward with this on January 4th when we all came back. And so they were very upset with us, and they because they wanted to come out again, with something strong in the new Congress. And we came back and we started to lobby intensely. Now, this kind of lobbying, and one of the messages that I want to bring you is that when we lobby on religious or on bills or regulations that have a religious tinge to them, we generally do it in the background. Our goal is to not allow these bills to get to the actual floor of the House or the Senate, because we want to kill them in committee or put in something that's favorable in the committee, so that when it gets to the floor, if it's killed in committee, if charitable choice is killed in the committee, then it's a hard slosh when it gets to the floor to make an amendment to the bill to put it into the bill.
Could you explain again charitable choice, what that means?
Charitable choice is language that does away with the safeguards of religious icons when religious organizations provide social services with taxpayer dollars, that they can commingle taxpayer money in their religious checkbooks, that they can provide the services in rooms with religious icons, that they can proselytize to the beneficiaries, saying, you know, you should accept Jesus in your life and then you'll do better, and that religious organizations can discriminate in hiring based on religion to administer the program.
So it's one of those misleading names, in other words.
Yeah, there's loads of those.
Oh.
Yeah, most all of them are like that. So the thing is that if it gets to the floor, if they have to put it into the bill, make an amendment to put it into the bill, then they need that supermajority to pass it. If it's in the bill and it's bad and we want to get it out of the bill, we're in the same situation where we need to really lobby hard a supermajority to get it out of the bill. So from our point of view, we want the work to happen in the committee. Now, regardless of what anybody has told you in the past, email campaigns really, really work. They work very, very well. They tell you that they don't work because they don't want you to be sending them emails, but they're so sophisticated with it that they have software programs that actually count your emails, and they count the number of words that are the same in the email, and they count the number of words that are different in the email, and then they give them a percentage. So if we send you a letter and we ask you to please send this in and you're in a hurry, go ahead and send it in because it will count. But it's even better if you alter it somewhat so that your language is different, because they still they give more weight to personal communications than they do to mass communications, but they still give lots of weight to mass communication. And mailing a letter doesn't work anymore, and I'm sure you all know that because of Anthrax. Everything goes to Philadelphia, and I mean everything, not just mail, but everything goes to Philly first, where they put it through the Anthrax Test. And if it's written, and we've seen this over and over again when we're on the Hill, they'll show us examples of it. You can't even read the letter anymore. It's got so much powder on it. It's been creased and folded so many times. They don't get it usually till 4 or 5 weeks after you've mailed it. So by then it's usually a moot point because they've moved on whatever it is that you're sending them. So phone calls and emails are really important. So the reason that so now that I've said that, when we get into a pissing contest with emails, when we have to do that, generally, folks with our point of view lose out because we don't have the mass numbers of people that the religious organizations do. So we try to avoid email wars with them. But once we send you one, we really want you to send it in because it's really going to count. Either it's gotten to the floor or it's just something that strategically we think it's really important that they hear from you, one way or the other. So with SAMHSA, what happened is we did everything pretty much in the background, and we really lobbied hard to get it taken out. And the interesting thing that really, for me, that turns around, the CARD Coalition is made up of secular and religious organizations. It's a very, very old coalition, not in its current form, but it's been around pretty much since the beginning of the Republic. And the reason is the Baptists were really concerned that the Catholics would be named the state religion. So, the other religious organizations, nobody wants any one religion to be given credit above the other religions. And so they're very invested in the First Amendment and the Establishment Clause and making sure they don't care about the no religion part like we do. They just don't want to have one favorite over the other. So we worked very hard on SAMHSA. We worked on it for a long time, and eventually we talked them into removing charitable choice. And it moved to the floor, and it was without charitable choice in it. Now, it still has to be worked on because it didn't get to the House that year. But that's just a sample of what goes on and what goes on in the background. And while I'm on this subject, I do want to bring up something else that I think is really important and part of my message to you. They built the visitor center, the Capitol Visitor Center. You're all aware of that. Have you all been there? Hasn't somebody not been there? Yeah, go.
I've been there.
Yeah, it's fabulous. I mean, it's in and of itself. It's It's a wonderful, wonderful thing. I spent 5 hours on one side, and they have a Senate side and a House side, and I'm going to go spend another 5 hours on the other side. But in any event, it's gorgeous, it's beautiful, it's a huge facility. And one of my personal friends in the Congress is Representative Debbie Wasserman Schultz. She comes from Florida, and she was put in charge of finishing the visitor center. And she's very much on our page on a number of issues, and so she made sure "In God We Trust" was not put anywhere in the visitor center. And she used the motto "E plurimis unus," from many comes one, and she accomplished all of that. And a House resolution was introduced, which you're probably familiar with, that said that they wanted to put "In God We Trust," and I don't know, whatever that other thing is about God that they always want everywhere. And so the House resolution was passed, and it got on some people's radar screens, and then people started a little email campaign about that. And I talked to Debbie's office about it, and they were well aware of it, and they were just going to keep it in committee. They were going to kill it in committee. They really didn't want to call attention to it. They didn't want any big campaigns going on around it. So that's what we did the first year, and nothing happened. And then the House resolution came up again, and some folks got a hold of it, and they started some very public campaigns about it. And this time, when it came around, the religious coalition, the religious organizations were aware of it, because unfortunately some folks on our side started an email campaign which put it on everybody's radar screen, and they started a war, an email war. And when it came out concurrently. It bypassed everything. Nobody had to vote on it. It came out as a joint resolution from the Senate and the House, and they're now installing "In God We Trust" in the Capitol Center everywhere. So that gives you an idea of what can go wrong if we are not strategic in our thinking and how we handle things with the Congress. So Head Start was another program that we worked on in 2007. We got, they tried to insert Head Start, came up for reauthorization, and into 2008. And the reason we won on Head Start, they inserted charitable choice language in committee, but we got it removed because in Head Start is its own little civil rights provision. So it didn't just rely on 1963, 1964 civil rights laws. They had actually, when they had originally penned Head Start, they had penned its own little civil rights piece. So because of that, because we could use that, then we eventually talked them into removing it. And Head Start was reauthorized without charitable choice in it. They also, in 1998, put it in the Workforce Investment Act, which reformed federal employment training, adult education, and vocational rehabilitation programs by creating an integrated one-stop system of workforce investment and education services for adults, dislocated workers, and youth. And it's in there. Now, Bush came along, and the Congress wrote H.R. 7. And H.R. 7 is a failed attempt to pass a global bill applying charitable choice to all social services programs and they lost due to hiring discrimination and our hard work. So when he came along, when he first came into office, they tried to create this global bill that would just put it into everything, which would have been a nightmare. But they did lose. We worked really hard on that, and that was really great. But because they lost, Bush created the faith-based initiatives. So charitable choice, when you think about it, think about the Congress. Faith-based initiatives, when you think about that, it is applying charitable choice, but via the executive branch. So the problem with it when he started to do it is that it conflicted with federal law as it was written. And the way that it conflicted was because of the hiring discrimination. And so the Congress tried to avoid anti-discrimination provisions, and we worked hard to stop that and had some limited success on that. So when Bush did this in his first days as the president, he established the Faith-Based and Community Initiative, and in these agencies. So in all of these federal agencies, there are faith-based offices to disseminate money to religious organizations. That's the way it stands today. So he did it with Executive Order 13198 on January 29th of 2001. And this is just one of the first paragraphs about it, one of the sections establishing it.
What would departments like Homeland Security and Justice, how would they be involved in faith-based initiatives in any way?
Well, I can tell you about justice, and I'm going to cover that just a little bit in the presentation, but in the Office of Legal Counsel, and this goes back to why it's so important that we pay attention to nominations that the president is making. Everything is just so interrelated, and sometimes when we send things out, people are like, well, why do we have to do this, and why are we paying attention to this? And this is a good example. The Office of Legal Counsel in the Justice Department, well, you know what? I'm going to wait until I get there. I've got it on the slide, so I'll answer that question. But I just want you to know about this Executive Order 13198. So this is where he established executive departments, in that they were supervised by a director appointed by the department head in consultation with the White House Office of Faith-Based and Community Initiatives. So the next order is Executive Order 13199, which establishes, this is all done on the same day. It all is rolled out on the same day. So Section 2 is the establishment of the office in Bush's White House. And we all know from David Cuono's book that came out and all the press that we saw of how it was used. Pretty essentially what happened is they stopped funding secular organizations. My cousin, this is really personal for me, my cousin works for Seedco, and over the years, we'd worked together locally in our community, because his job was to go out into the community and train local organizations on how to apply for the government funding and, set up the social services programs. And when Bush came into office, he was pretty much ordered not to engage secular organizations any longer. He had to do outreach locally into communities, into religious organizations, and then and Seedco is a nonprofit that uses government grants and fundings to do this work, and so that those grants and fundings were threatened if they didn't follow what the White House wanted, which was to do outreach to the religious organizations. And in fact, the Resource Center for Women, in the first year that this happened, went in for a training and got money for a program that we were doing with women and children. And we got the money and we did the program, and it was very successful. It was so successful that our executive director was brought up to one of the conferences here, and we were highlighted as an example of really using the money well. We were never funded again. And in fact, all of the funds dried up, and we had to close. After 25 years, we had to close the Resource Center for Women in Pinellas County, which was really sad. And I think that that's fallout. I don't know how many secular organizations are gone that did this kind of thing. I don't think that there's been very little press on that. So then in 2002, December 12 of 2002, Bush issues Executive Order 13279, and he calls for an end to discrimination against faith-based organizations and orders implementation of these policies throughout the executive branch. So he directs that faith-based organizations be allowed to retain their religious autonomy over their internal governance and composition of boards, and over their display of religious icons, scriptures, or other religious symbols when participating in government-funded programming. So he issues an executive order to do away with this law. I mean, for me, to realize how one branch, interacts with another branch and just decides, well, we're not going to follow this law anymore, and this is how we're going to do it. I just think it's amazing. So following on the same day of this order, the Department of Health and Human Services, which at that time was under Tommy Thompson, remember he was the guy, I think, from Wisconsin that was really He issued a press release announcing a proposed new regulation for the department to implement this order, and included in the bullet points for the statements that religious organizations may retain a religious environment and religious symbols in their facilities where HHS-supported services are delivered. That means with our taxpayers' dollars. And religious organizations that receive funds from covered programs have a federal right under existing civil rights laws to take their faith into account in making employment decisions, permitting them to limit hiring to employees who share their religious beliefs. So this is in 2002. So the rule comes out in August 16th, 2004. There's another rule that revises the department regulations to remove barriers to the participation of faith-based organization and department programs and to ensure that these programs are implemented in a manner consistent with applicable statutes and the requirements of the Constitution regarding blah, blah, blah. Yeah. So it's just this march. It's just this continual march over these years that this is being instituted, you know, over and over again in all of these places. So
maybe you're going to cover this, but how do they determine what is a religious organization?
That's a really good question that just comes up, and it's kind of, it was done, actually it came out in the book that the way that they just decided. They would just have one or two people that would sit in the White House in the Office of Faith-Based Initiatives and Community Initiatives that would just look at the applications and go, oh, this is not a religious organization, and they wouldn't even consider it. Oh, this is a religious organization, and they wouldn't. It was very arbitrary. There was no set of guidelines or rules. Also, they stopped keeping data and statistics when they instituted these programs.
Would you go back one slide, please? Just didn't catch that last part.
I think 1984.
The part that makes no sense.
Yeah, that's right.
Yeah, but they use, I put this up here, so I didn't want to be like unfair and just like put up things. I mean, this language is actually in there, but it's that same very, you know, so you read this stuff and you go, oh, thank goodness, except then you see these other regulations that are saying, oh, but you don't have to do this stuff, you know, or the way that we view this is religious discrimination is allowed. Good? Okay, so further, some, if not most, religious organizations are not following the guidelines and steps are not being taken to monitor and bring them into compliance, which is something that we as a coalition are paying attention to and we're complaining about and we're writing letters and we're lobbying and we're saying, look, we want you to do this. We were trying to get Henry Waxman's oversight committee in the Congress to start looking into this for us, and it was we didn't get very far with it at all. But that was one of the places where we were lobbying. We were saying, look, this stuff isn't happening, so we need for you to step up on this. But you know, there was so much going on then. Anyway, so the measurement of the effectiveness and performance of these programs was supposed to be required. All right, now I'm going to introduce this here, kind of like in the middle of, because this is so intertwined. This is the Religious Freedom Restoration Act, H.R. 1308, and came into being March 11th, 1993. So this is prior to 1996 when charitable choice came into being. All right, so the Congress finds that the framers of the American Constitution recognizing free exercise of religion is an unalienable right secured its protection in the First Amendment to the Constitution. Laws neutral toward religion may substantially burden religious exercise without compelling justification. This is the new thing in 1993, that as far as I know, for the first time, it's always been couched that if a law is neutral, you know, it's not secular, it's not religious, it's neutral, that would protect us. But they have now introduced this act that says laws that are neutral toward religion substantially burden religion. And they make a new requirement that the government has to have compelling justification. Are there any attorneys in the room? Okay, so this has to do with strict scrutiny.
It's a very high barrier.
Right. So do you just want to briefly tell people about scrutiny? There's 3 of them, right?
Yeah, well, yeah, basically. There's when a court is weighing the constitutionality of a law, they can there's different levels of scrutiny, and you can have rational basis where you only have to articulate some sort of plausible connection between the legislative goal and the rule. There's strict scrutiny where there has to be a compelling governmental interest that is closely furthered by the rule, and there's intermediate, which is somewhere in between. So you typically apply strict scrutiny to something that limits like a First Amendment right. And they're saying a neutral law would still be subject to strict scrutiny, even though it looks neutral. Ordinarily, you wouldn't, have that. You'd only have to say there's some rational basis for whatever, zoning laws that apply to a church.
Right. So this is a really complicated act that came about because of many cases. But the other thing I wanted you to know is that this act applies to all federal and state law. So the Supreme Court declared parts of the act unconstitutional on June 25th of 1997. The act had to do with, there were a number of cases that it had to do with, and you maybe probably know more about this than I do. I know there was the Smith case, and there was a Native American case. There was a case where a woman, and I think she was in the Carolinas, one of the Carolina states, and she didn't want to work on Saturdays because her religion was opposed to working on Saturdays, and so they fired her because she needed to work on they needed somebody to work on Saturdays, and so then they denied her unemployment benefits because they felt she could work on Saturdays, and so she sued because of her religion. Now she won that case. Then there was a case in I think the state of Washington, and there were two Native Americans, and they were smoking peyote. And that was part of their religious freedom as far as they were concerned. And interestingly enough, they worked for, I think it was a drug program. So, I mean, it was really egregious that they were smoking, I looked it up. It's not pot, it's mescaline, and I don't really know what mescaline is, but whatever. Yeah, it comes from a cactus. So,
it is legitimately a part of their
it really is.
I believe in the 1960s, the Supreme Court ruled on that. They were allowed to do this part of their religion.
Right, exactly, that's right. Well, no, what happened is that the Supreme Court, so anyway, they went for unemployment because they were fired. And the state said, no, we're not going to give you unemployment on this, so they sued. So Scalia was one of the people that wrote on this, and what they said is that because the law was neutral, it wasn't saying that there was something wrong with their religion, it was just that nobody was allowed to do drugs on the job. They lost. And that was one of the big reasons why the Congress wrote this act, this Restoration Act, and said that there had to be the standard of strict scrutiny. In the U.S. Department of Justice, the Office of Justice Programs, the Office of Legal Counsel provides authoritative legal advice to the President and all the executive branches. And now I'm going to get to your question about the Justice Department and what they may have to do with this. This is where it's coming in, right? So in October of 2007, they issued a ruling. It was called the Effect of the Religious Freedom Restoration Act on Faith-Based Applications for Grants. So that's why I'm talking about this now, is because they took this law and they applied it to charitable choice and faith-based initiatives. And let's see so they concluded that the Religious Freedom Restoration Act is reasonably construed on a case-by-case basis to require that its funding agencies permit faith-based organizations both to receive federal funds and to continue considering religion when hiring staff. As described more fully below, RFRA protects this right to preferred co-religionists for employees even if the statute that authorizes the funding program generally prohibits consideration of religion in employment decisions by grantees. So they now have a ruling from our Justice Department that says that they can legally discriminate in hiring based on religion. and this is in 2007. So now back to why it's important that we pay attention to nominees. This is where this comes in. President Obama has nominated Don Johnson to run the Office of Legal Counsel at the Justice Department. Dawn Johnson has a wonderful record as far as our issues are concerned. She has a very, very long history, a very, very long record. But one of the first jobs that Dawn Johnson took was, I think she was counsel for NARAL, for the National Action League for Abortion. Yeah. And so because of that, the religious right and these folks in the Senate that are opposed to abortion have stalled her appointment. They won't let her come up. They won't let her be voted on. Now, we want her in office. He's been in office for over a year, so we've had this Office of Legal Counsel for over a year with nobody running it. So that in and of itself is a problem with nominees. All these nominees that are stalled means no work is, or the really good work that could be done is essentially not being done because there's nobody running these departments. But number two, for us, we want this rescinded. But we can't get it rescinded because there's nobody that is running the office.
How long can they keep a hold like that going?
Well, I don't know. They've been doing it over a year now. And now the appointments at the end of the year, or the nominations at the end of the year were up. So he has to decide, Obama has to decide, is he going to renominate? Now, it just came out yesterday that he did renominate Don Johnson. He is renominating a lot of people. So that's very good. So, but we're no further ahead than we were before in getting her. So when we send something out to you and we ask you to send a letter and it has to do with nominations, there is in the background, in this very convoluted, confusing way, a reason why we're asking you to do this that's going to advance our causes. We hope.
When you send out that sort of alert, for those of us who live in D.C., is it, I mean, is there any point in writing to someone else's senators? Do
Well,
they even get through to them, like when it's email?
sometimes I'm not supposed to do this, but sometimes what we do is we we have it set up so it goes to the committee.
Okay.
And so and sometimes they go through and sometimes they don't because the companies that administer the email program with the Congress are under contract to do certain things, and sometimes they're not supposed to allow those to go through, but sometimes they do, and we take the chance. And so, yeah, if we just, if it lets you send it through, then send it through. If it doesn't, then it doesn't. It's kind of, because sometimes you'll get it back when you're in DC and it says that you can't do that. It is very frustrating, I know, very sad. So in any event, that's what the story is on that, and that's why that's important. And this is where the government gets its authority. And the big frustration for myself personally, and I know for others that I work with, is that we really were hoping that when Obama got into office that we would see these. I remember like back in 2008 in October, and everybody here probably remembers midnight regulations. Remember, they were feverishly writing these midnight regulations. The Bush administration, they were going to come into effect on January 19th, and they needed 65 days. And remember, Clinton did it prior to that. But Clinton's folks didn't do it right. So they didn't have like the 65 days or, there'd be this loophole or whatever, and a lot of their stuff didn't get through. Well, the Bush administration got it right, and they did get a lot of things through. And I remember even in the meetings that we would say, well, so what, so what if this goes through? The new administration's going to come in, and they're just going to, do away with this, yada, yada. Well, no. And we were told back then, no. That this was really important to work on trying to get these things stopped, because usually on the regulations they have to open it up to public comment, and there's so many days for public comment, and then they have to consider all of that public comment. So we were like driving emails saying, please send in these public comments, which is another thing. When we ask you to make a public comment to a department on a regulation, it is really important because there is law and they do have to consider this. Now we may not get anywhere, but if we're not there to stop them, it's going to be worse than it is now. They're just going to run all over us. So these are all the tactics and all the way, when they talk about the way Washington works, this is the way that it works. It's very difficult to change it. But in any event, as a coalition, we've even written it's called a rescission order. And as a coalition, we've written a rescission order and presented it to the White House staff asking them to please, take action on this. And we're very frustrated because they're not doing that. Now, this could go back to the fact that they don't have anybody in the office that can do it yet, but maybe we thought there might be a workaround. But it's part of the work that we do. We actually help write legislation, and we help write these orders for them. Okay, so, and this is what I'm saying to you here, is that we wrote to the U.S. Attorney General, Eric Holder, to request that he direct the OLC to review and ultimately withdraw this memo. We think that it's vital for the protection of religious liberty and civil rights. So, okay, so now I'm at faith-based initiatives under Obama. I don't know how I'm doing on time, and I'm the kind of person that can, talk forever, so you have to, let me know.
Your slideshow's been running for 47 minutes and 52 seconds.
Oh, well, great. That's very cool. Okay, so, well, I'm not going to get beyond faith-based initiatives into those other things anyway today. It was too much to cover. But anyway, so
What were the other things, just briefly, though? 'Cause
the other things were, well, I might like to get to the HHS ruling because I think that's really important. And one was spiritual care, which is in the health care bill right now, which is just explicit. What's that word? When you want to swear, explicitive.
Yeah, but I was kind of interested in the ones about healthcare and that are related to healthcare. I was wondering what's going on in that area.
Yeah, well, I'll get there. Let me just get through. This isn't going to take me very long. We're really disappointed with Obama because on February 5, 2009, he wrote an executive order that amends 13199, Bush's original thing. And all he did was he established the President's Advisory Council for Faith-Based and Neighborhood Partnerships instead of community. He just changed the name. And then he did that as the Pres. And so he calls it the council. And he has 25 members on it that serve for 1 year, and they're reappointed at the direction of the president. And this is set up for 2 years, unless he renews it. So this is his mission. The council shall bring together leaders and experts in fields related to the work of the faith-based and neighborhood organizations in order to identify best practices and say blah, 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 blah. Pretty much the same stuff. And he set up 6 task forces. One of them it's about fatherhood. One of them is how to reduce unintended pregnancies in teenagers, and it just goes on and on. We're also concerned that we don't think he's following FACA, which is something the Center for Inquiry wrote some legislative language on. FACA is the Federal Advisory Committee Act, which allows the public to sit in on these meetings. The out for them is that if they're organizing, they don't have to let us in the room, and so they've spent the whole year organizing. So we just got to our first meeting. We sat in the first meeting, which was the report of the 6 task forces that they were going to present to the president. And we were very, very disappointed in the reports. It was like everybody was on the faith-based bandwagon, and they want to put faith-based offices now in every embassy in the world. I mean, they just want to expand, expand, expand. So it's really a pretty crazy thing. And it's something that we're monitoring, and we're not real happy with him about. So I'm through on that. I'm through with all that. And so I did put this up here, which is the proviso refusal or conscience regulation. This isn't about spiritual care. You wanted to know about spiritual care?
Well, yeah, I just wondered what's going on in that area. I mean, does it have to do with things like what kind of end-of-life treatments are available to you, that kind of thing?
Actually, that's this, which is why I put this up here. This is the provider refusal clause, which doesn't have to do with the health care bill. And this is something else that we've written a rescission order on that we've been totally ignored on, and we're really upset about this. So this is a rule there. Okay, there are these 3 federal statutes: the Church Amendment, the Public Health Service Act, and the Weldon Amendment. And collectively, in material part, the statutes provide that certain health care workers and entities cannot be discriminated against if they refuse to engage in, provide, pay for, or provide coverage of certain activities or procedures, in particular abortion and sterilization. Now, when this first came out, they were just going to institute this. They weren't even going to ask for public comment. So that's the first thing that we found out about and that we really lobbied against, and we said, you have to, it's a law, you have to do this. So we got them to open it up, and when we first read it, for public comment, and when we first read it, the definition of abortion was so broad that it could include all birth control, which, you know, we didn't think that they were innocent in that. We thought that they knew what they were doing. And so we got them to change that. And then we asked everybody to make comments to, this was one of the places where we wanted comments to be made to the Health and Human Services Department. And actually the coalitions themselves, many coalitions worked on this. This wasn't one coalition, lots of coalitions worked on this. We got over 225,000 comments driven to their website that they had to consider. However, it didn't matter because they passed it anyway. But this is the regulation that is so broadly written that it would do away with your end-of-life wishes. There are specific examples in this regulation that say a janitor doesn't have to clean the floor at a hospital if an abortion was performed there. If you're in a rural area and I'm a receptionist and I'm whatever religion it is that decides that you have to have children no matter what, and you call me up and you're a male and you say you want to have a vasectomy and I'm opposed to that. Also, the way this regulation is written, it's not just religious, it's religious or moral. So I always think about, like, well, what if you got in a fight with somebody and you pissed them off and they decided that morally they don't want to provide you with this, that this would allow them an out. So I'm a receptionist, you call up. I not only don't have to make an appointment for you to see the doctor, I also don't have to tell the doctor that you're trying to get an appointment. I don't have to refer you anywhere else. I don't have to let anybody know about this. And it originally started, and this is in a lot of states, and it originally started with birth control and the emergency contraception. And then many of the laws were written so that the pharmacists could refuse, but that they had to refer you to somebody else. Well, now under this, if you turn in your prescription and they don't want to fill it, they don't have to give it back to you. Not only don't they have to fill it, not only don't they have to refer you, they can keep your prescription. I mean, it is outrageous. So our position is that there's no evidence that the regulation is needed. The proposed regulation cites no factual support for its supposition that healthcare professionals are at risk of being subject to illegal discrimination or that persons are discouraged from entering the healthcare profession because of concern about discrimination, which is what they state. This is CFI's positions. The regulation's rationale is based on a thorough misunderstanding of employment discrimination law as applied to workers outside the healthcare professions. The regulation provides far greater rights to healthcare workers than are enjoyed by workers in other professions while improperly discounting the rights of patients. But you know that over a third of the hospital systems in the United States are owned by the Catholics. And you know that when you check into a Catholic hospital, all that little small print that you sign says, we're not paying attention to your dying right wishes. And that's going on today even without this. And I think that most people don't know that, but it's really something that you should let everybody know about. Because Catholic hospitals, the final authority for them are the bishop or the archbishop of the district where they reside. They're not called districts, whatever they're called. I know this because when I was in Florida and I worked down there, we were taken over. And they take over in a stealth way. They now don't just own the hospitals, but they create alliances. They call them buying alliances so that they all get together and join this alliance so that they can buy things for cheaper. Except that they all have to, all the hospitals that agree to join the alliance agree to abide by Catholic precepts and the rules of the bishops. So the absence of a specific scientifically supported definition of abortion and or sterilization will cause confusion and could result in contraception misunderstood by some as a form of abortion being included as a service to which healthcare providers will object. And that's the end of my slideshow.
Thank you.